Hello everyone, and welcome to another video from Schnee Legal Services, LLC. I'm Jay. Chadwick Schnee, an attorney here to help you navigate the complex world of Pennsylvania law. Today, we're diving into a critical topic for anyone involved in litigation: how to file a petition for allowance of appeal from decisions of the Pennsylvania Commonwealth Court or Superior Court to the Pennsylvania Supreme Court. If you've received an unfavorable decision from one of these intermediate appellate courts, this process could be your next step to seek justice. Stick around to learn the ins and outs, and if you need personalized guidance, I'm here to help at Schnee Legal Services. Let's get started. Before we dive in, a quick disclaimer. This video is for informational purposes only. It is not legal advice, and watching it does not create an attorney-client relationship. Every case is unique, and you should consult with a qualified attorney to discuss your specific situation. If you'd like to learn more about how we can assist you, visit us at www.schneelegal.com or give us a call. Now let's talk about the appeal process. So, what is a petition for allowance of appeal, or PAA for short? In Pennsylvania, if you've lost a case in the Commonwealth Court or the Superior Court, you may want to ask the Pennsylvania Supreme Court, the highest court in our state, to review that decision. But here's the catch: the Supreme Court doesn't have to take your case. Unlike the intermediate appellate courts, which generally hear appeals as a matter of right, the Supreme Court has discretionary jurisdiction. That means they pick and choose which cases to hear based on specific criteria. Filing a PAA is your way of convincing them that your case is worth their time. Let's break this down step by step so you know exactly what's involved and how Schnee Legal Services can guide you through this process. Step 1. Understanding the grounds for appeal. The Pennsylvania Supreme Court doesn't review every case. According to Pennsylvania Rule of Appellate Procedure 1114, the court will consider granting a PAA if your case involves a question of first impression, meaning the issue hasn't been decided by the Supreme Court before, an issue of substantial public importance, something that affects a large number of people or has broad societal impact. A conflict between decisions. If the Commonwealth Court or Superior Court's ruling contradicts another court's decision or creates inconsistency. A significant constitutional question, especially if it involves federal or Pennsylvania constitutional rights. Or an error in the lower court's application of law, like if they got a key legal principle wrong. For example, let's say the Commonwealth Court upheld a school board's decision to impose a policy you believe exceeds their legal authority, like in a recent case involving mask mandates during the COVID-19 pandemic. If that issue raises a novel question or has statewide implications, it could be a candidate for Supreme Court review, but you need to frame your argument carefully to meet these high standards. Step 2. Timing is everything. Timing is critical. Under Rule 1113, you have 30 days from the date of the Commonwealth Court or Superior Court's final order to file your PAA with the Pennsylvania Supreme Court. Miss this deadline, and you could lose your chance to appeal. If you're considering an appeal, don't wait. Reach out to an experienced attorney like myself at Schnee Legal Services right away. We can help ensure your petition is filed on time and meets all procedural requirements. Visit www.schneelegal.com to get in touch. Step 3. Drafting the petition. The PAA itself is a formal legal document and it needs to be persuasive. Here's what it typically includes, based on Rule 1115. A cover page identifying the parties, the lower court's docket number, and the case caption. A statement of jurisdiction explaining why the Supreme Court has the authority to hear your case. The questions presented for review, these are the specific legal issues you want the court to address. They need to be concise and tied to Rule 1114's criteria. A statement of the case summarizing the procedural history and key facts. The reasons for allowance of appeal, where you argue why your case meets the Supreme Court's criteria: public importance, first impression, or legal error. A conclusion, requesting that the court grant your petition. You'll also need to attach a copy of the Commonwealth or Superior Court's opinion and order, plus any other relevant documents. The petition must be clear, concise, and compelling. This is where having an experienced attorney makes all the difference. At Schnee Legal Services, we've handled complex appeals and know how to craft arguments that grab the court's attention. Step 4. Filing and serving the petition. Once your PAA is ready, it must be filed with the Pennsylvania Supreme Court's prothonotary, typically in the appropriate regional office, Harrisburg, Philadelphia, or Pittsburgh, depending on where the case originated. You'll need to pay a filing fee, unless you qualify for a fee waiver. You must also serve copies of the petition on all parties involved and file a certificate of service. The opposing party has 14 days to file a response called an answer to the petition for allowance of appeal under Rule 1116. This process involves strict formatting and procedural rules like page limits and font sizes outlined in the Pennsylvania Rules of Appellate Procedure. Mistakes can lead to your petition being rejected, so it's wise to have a lawyer who knows the system. That's where we come in at Schnee Legal Services. Let us handle the details so you can focus on your case. Step 5. The Supreme Court's decision. After your PAA is filed, the Supreme Court will review it and any responses. They may take weeks or months to decide whether to grant or deny your petition. If granted, the court will schedule briefing and possibly oral arguments. If denied, the Commonwealth or Superior Court's decision stands, and your options may be limited, though you could explore federal court in rare cases involving federal law. The Supreme Court grants very few petitions. Only about 5 to 10% of PAAs are accepted, so your petition needs to stand out. This is why working with a skilled attorney is crucial. At Schnee Legal Services, we analyze your case to identify the strongest arguments and present them in a way that maximizes your chances. Why this matters to you. Filing a petition for allowance of appeal is a high-stakes process. It's your chance to correct a wrong decision, clarify the law, or address an issue that could impact countless Pennsylvanians. Whether you're challenging a Commonwealth Court ruling on a government policy or a Superior Court decision in a civil or criminal case, this is a complex area of law that requires expertise. I've seen firsthand how these appeals can make a difference, and I'm passionate about helping clients like you seek justice. Call to action. If you're facing an unfavorable decision from the Commonwealth Court or Superior Court, don't navigate this alone. At Schnee Legal Services, LLC, we're here to guide you through every step of the appeal process, from evaluating your case to crafting a compelling PAA. Visit us at www.schneelegal.com to schedule a consultation or give us a call to discuss your options. We're committed to fighting for your rights and helping you achieve the best possible outcome. Attorney Schnee, thanks for watching, and I hope this video has given you a clearer understanding of the petition for allowance of appeal process in Pennsylvania. Don't forget, this isn't legal advice, so reach out for personalized guidance. Check out www.schneelegal.com